One word. That's what I want you to focus on right now. Not the charges, not the constitutional process, not the historic nature of what just happened in Washington. One word. And that word, that specific, legally precise, morally unambiguous word, is now permanently embedded in the congressional record of the United States of America, written into a formal impeachment document, filed under oath by a sitting member of Congress against the sitting Attorney General of the United States. The word is pedophiles. And Washington, a city that has processed a generation of political scandals without flinching, has gone quiet in a way that tells you everything you need to know about what the people inside that city understand that word in that document to actually mean. Here is what we know. Congresswoman Summer Lee has formally introduced articles of impeachment against Attorney General Pam Bondi. The charges are 3. And I want to walk through each one carefully because the coverage of this story is treating them as a bundle, as a single political attack, when in fact each individual charge carries its own devastating legal weight entirely on its own. Charge 1, defying congressional subpoenas. That is not a policy disagreement. That is not an administrative delay. That is contempt of Congress, a documented on-the-record refusal to comply with the legally binding demands of the legislative branch of the United States government. Charge 2, ignoring federal court orders. Not slow-walking compliance, not disputing interpretation, ignoring. A sitting cabinet officer telling a federal judge that the order entered from that bench simply does not govern her conduct. Charge 3, perjury. And I need you to sit with that one for a moment. Perjury is not a constitutional violation. It is not an ethical breach. It is a federal crime punishable by imprisonment, allegedly committed by the person whose department is responsible for prosecuting perjury committed by everyone else in this country. Put all 3 charges together, and the picture that emerges is not of a cabinet officer who made mistakes under pressure. It is of a cabinet officer who made choices. Deliberate, sustained, documented choices to place herself above the very law she was appointed to enforce. Now, back to that word. Because the language of this impeachment document is the most significant legal and political development in this entire story, and it is the element that the surface level coverage is processing as rhetoric when it is something structurally far more consequential than that. The accusation that Pam Bondi acted to protect pedophiles is not inflammatory language inserted for political effect. It is a legal characterization, a conclusion about the specific category of individuals whose names and associations the Epstein files document. And it is the explanation the articles of impeachment offer for why Bondi chose defiance over compliance again and again and again. When a member of Congress writes that into a formal impeachment document, she is not making a campaign statement. She is not sending a press release. She is entering a legal conclusion into the permanent congressional record under her name, under her oath, with the full institutional weight of the impeachment process standing behind it. Congresswoman Lee has concluded, based on the documented record of Bondi's conduct, that the only coherent explanation for the sustained, multi-layered, legally defiant suppression of the Epstein files is that those files contain information about specific individuals whose protection was worth more to Pam Bondi than her office, her freedom, and her constitutional obligations. That is not a small thing to say. That is an enormous thing to say. And she said it in writing, on the record, forever. Let's talk about the Epstein files themselves, because the public accounting of what those files actually represent remains catastrophically inadequate. The Jeffrey Epstein investigation was not a closed chapter of American legal history. It was one of the most extensive federal investigations into elite criminal networks ever conducted, producing millions of pages of documentary evidence. financial transactions, travel records, communications, personal associations involving individuals who did not stop being powerful when Epstein died in a federal jail cell in 2019. The names redacted from the documents Bondi's DOJ has released are not random. Congressional investigators who have reviewed even the partial disclosures describe a pattern of redaction so consistent, so specific, so deliberately organized that it cannot be attributed to accident. It reflects a prioritized effort to protect certain categories of individuals. Individuals whose documented associations with Jeffrey Epstein, if fully public, would generate consequences that Pam Bondi has apparently concluded are more catastrophic than the consequences of an impeachment trial. Think about that calculus for a moment. The Attorney General of the United States looked at an impeachment proceeding, the most powerful constitutional weapon Congress possesses, and decided that the alternative was worse. That decision, made by that person in that office, is itself the most damning document in this entire case. Congresswoman Lee's decision to introduce articles of impeachment rather than a resolution of inquiry, rather than a special committee request, rather than any of the intermediate steps that typically precede this kind of action, is a strategic choice that deserves serious analysis. She skipped every intermediate step and went directly to the most powerful instrument the legislative branch possesses. You do not do that if you are still building a case. You do that when the case is already built. The subpoena defiance is not alleged, it is documented. The court order violations are not disputed, they are established. The perjury is not inferred, it is on the record. Lee went directly to impeachment because the evidentiary foundation was already complete before she filed a single page. The articles of impeachment are not the beginning of an investigation. They are the constitutional conclusion of one. The situation Pam Bondi now finds herself in is unlike any professional crisis any attorney general in American history has faced. And here is why. When Bondi was simply stalling, missing deadlines, redacting names, managing disclosure timelines, the strategy was containment. Limit what becomes public. Run out the political clock. Hope that the will to force the issue dissipates before the issue is forced. Impeachment is not containment. Impeachment is exposure. It is a constitutionally mandated, publicly conducted proceeding in which the evidence underlying the charges must be presented, examined, and entered into the public record. Every document Bondi's DOJ has withheld becomes potentially relevant evidence. Every subpoena she defied, every court order she ignored, every redacted name, all of it is now potentially subject to the constitutional authority of the United States Congress, operating in its most formal, most irreversible, most publicly visible capacity. The vault that powerful people spent enormous resources keeping sealed is now subject to a process that does not negotiate, does not delay, and does not accept executive privilege claims as an answer when the person making those claims is the one on trial. And the panic spreading right now through the networks of attorneys and financial advisors and political intermediaries who represent the individuals whose names are buried in those files is of a specific and acute character that Washington has genuinely not seen before. Because those people understand something that the cable news chyrons are not yet capturing. The question that the impeachment hearing will ultimately build toward is not about Pam Bondi's conduct in office. It is about whose names are in that vault and why she thought protecting those names was worth all of this. There's one more piece of this that I want to make sure we don't move past too quickly. The perjury charge. Because perjury, unlike the other charges, does not resolve with the impeachment proceeding. It survives it. If Bondi is impeached and removed, she faces potential criminal prosecution for perjury as a private citizen without the institutional protection of the Attorney General's office around her. If the Senate fails to convict, if the politics break the wrong way and she keeps her job, the perjury record established in the House proceedings remains available to a future DOJ or to a special counsel as the documentary foundation for a criminal referral. The impeachment process does not resolve Pam Bondi's legal exposure in the perjury dimension. It compounds it. Every statement she makes going forward in the impeachment proceedings, in any parallel congressional testimony, in any public communication, is a potential additional count on a criminal exposure that these articles of impeachment have now formally placed on the record. There is no statement she can make that doesn't carry risk. There is no answer that closes the door she has opened. Inside the Justice Department right now, career officials who have served through administrations of both parties, people who maintained their institutional neutrality through every political storm this building has ever weathered, are confronting something categorically different from anything they have faced before. The institution they have spent their careers protecting is now led by an attorney general facing impeachment for crimes allegedly committed in the exercise of the office they serve. The DOJ's credibility, its ability to prosecute perjury while its leader is charged with committing it, to enforce subpoenas while its leader is charged with defying them, to operate federal courts while its leader is charged with ignoring their orders, is under a form of institutional stress that no crisis management protocol is designed to handle. And the timeline going forward is not Bondi's to control. Congressional impeachment proceedings operate on the House's schedule, not the Attorney General's. The Judiciary Committee will set hearing dates. Witnesses will be subpoenaed. Documents will be demanded, and the delay tactics that characterize Bondi's management of the Epstein file situation to this point, privilege claims, scheduling objections, document disputes, carry a fraction of their prior effectiveness in a proceeding whose subject is not a policy dispute, but a set of specific constitutional charges documented with specific evidence filed under the full constitutional authority of the House of Representatives. That authority does not negotiate. It operates on its own timeline. And that timeline is now running. When Pam Bondi walks into that impeachment hearing room, it will be the most consequential moment in the history of the Jeffrey Epstein investigation. More consequential than his arrest. More consequential than his death. More consequential than any partial document release that has preceded this moment. Because for the first time, the full force of a constitutional proceeding will be directed not at the investigation of Epstein himself, but at the systematic suppression of what that investigation found. Bondi will not be answering questions about Epstein. She will be answering questions about why she chose to protect the people the Epstein investigation documented. And that distinction, the difference between investigating a crime and investigating the cover-up of a crime's findings, is what makes this proceeding unlike anything that has come before it. The arithmetic is brutal, and it has no exit. Comply with the disclosure demands and detonate the lives of some of the most powerful people on earth. Resist and face an impeachment trial that forces those disclosures anyway, while adding criminal exposure for every act of resistance along the way. The vault cannot stay sealed. The constitutional process now in motion does not permit it. The only remaining question, the question that will define Bondi's legacy, determine her legal fate, and potentially reshape the political landscape of this country, is whether the contents of that vault emerge on her terms or on Congress's. Based on everything the documented record shows, Congress has already decided that question. If you want to follow every development in this story as it unfolds, subscribe. Because this is far from over.